Ladies and gentlemen, welcome to Video Game Law. This is Suzanne Jaciw. Is that how you pronounce
Yep.
it? I remember from last year. And Hersemann.
Hello.
They are law professionals specializing in video games. And for those of you devs out there, there are a lot of you, I know. Please stick around for this. This is very informative for all of you. I'll be moderating the questions. I'll also be pulling questions. There's already a question in chat. I'll be pulling questions from the chat, so feel free to do that. And first of all, let me ask the two of you if you could just tell us a bit about yourselves.
All right, Suzanne, ladies first.
All right, so I'm an attorney with the IE Law Group, which is a law firm out in LA, but I'm based in Chicago. We're a bunch of lawyers that only work in video game law, so our clients are all over the world. They're publishers, they're developers, they're huge AAA groups, they're indies, and we only do transactional and business side matters, so you'll never, ever, 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 ever see us in a courtroom, which is wonderful. I'm also a certified information privacy professional, which means that I know a lot about privacy law, terms of service, and things of that nature. In addition to all of the law stuff, I'm operations director at a mental health charity called Take This. I help with a game development camp and a local games festival. And I'm project manager at the Video Game Bar Association, which is the giant club for all of the video game attorneys all over the world. Ross?
And I'm Ross Hersemann. I'm a solo practitioner out of Chicago, also working exclusively in video games. I'm also a board member of IGDA Chicago, the video game art gallery. And I run a blog called Loading Law that discusses legal issues in video games. And keep an eye open for my book on video games coming out next spring.
Awesome. So the first thing we'll jump into that I think a lot of people have questions, not just in video games, but in general now with things like YouTube and all that sort of stuff, is copyright. So what exactly is copyright, and what in a game can you copyright?
Well, copyright is, according to the legal system, an original work of authorship fixed in a tangible medium of expression. In video games, that means it's anything from the video, the written script, the narrative, photographs, music. All of the creative expression goes into a game is usually covered by copyright.
Awesome. Okay. So, sorry about that. My computer does stupid crap sometimes, so the stream is probably frozen.
Technology, what?
Yeah. There we go. Sorry about that. Okay, so the next question, did you already explain what in a game you can copyright?
Yes.
Okay, good. So how does someone get a copyright, and how long does a copyright last?
So one of the interesting nuances to copyright is that you technically don't need to register one in order to have a valid copyright. As soon as your creative work becomes fixed, as soon as you write it down, as soon as you record it, as soon as it's a physical, tangible thing, you already have a copyright interest in it. There are some advantages to registering a copyright forever. For instance, if you want to prosecute someone for copyright infringement, if you want to have a timestamp of when you created something, it's very important for copyright is the date of creation, the original time of authorship. Copyright registration for that is all very, very good, especially for video games. Copyright is one of the easiest intellectual property protections to achieve. The filing fees with the Copyright Office are only $35 for a particular work. Now, depending on the work, you might have to layer your copyrights to cover different things, the video, the narrative, the music. So you might be covering a couple different things, but it's definitely one of the easiest legal protections to achieve for a video game.
And specifically for games too, the coding and assets and things like that probably. And actually recently I think there's been some news and some assets theft as far as that goes for a game called Orion. So how does one know like if they are actually infringing on someone else's copyright?
Usually the person you're infringing on will tell you. You'll be the first person to find out. Copyright infringement comes with its certain statutory penalties, but for the most part, copyright is one of the easiest things to litigate, but one of the most seldom litigated as well, because it's one of those things where everyone does it, so no one's guilty. If you just look on Google, you'll see any number of copyright infringing images copied, pasted, shared everywhere. YouTube videos featuring cover songs. There's so much content floating around out there that technically is infringing copyright, but because so many people do it, it's just kind of legion. So what I tell my clients is I always tell them the strict letter of the law when it comes to copyright, and I always tell them you never want to be the person to roll the dice on copyright infringement. So do what you're supposed to do and try to stay out of trouble when you best you can.
All right. So doesn't all that, I mean, you kind of went into it a bit, but doesn't that all go into litigation when people infringe on copyright, especially with fan art and mods and things like that maybe people aren't necessarily making money off of, but sometimes are?
For the most part, your average copyright infringement doesn't even make it to litigation. The way that it usually comes down is, say someone makes a piece of fan art, writes a fan story on a particular license, or is making merchandise off a particular property and selling it at conventions or on an Etsy page or online. They'll typically get a letter from the copyright holder saying, we saw your website, we saw your things out at a convention, this is how much we think you made, we own the rights, if you give us that money back plus usually a little extra for the trouble, it'll all go away. We don't need to pursue litigation. And that's usually where it ends for most people, because copyright infringement is a very long road when it comes to litigation, and your average copyright infringer doesn't have the pockets to be doing that. If they did, they probably wouldn't be infringing in the first place.
Right. Is there like a rule of thumb for how different something should be to avoid the infringement?
As different as it can possibly be. When someone asks me like where that line is, they're already in trouble. And it's a problem because some of the most creative things, I think, are fan works, are fan art and fan stories and fan fiction. I love reading them, and I'm sure most of our viewers do too. But the way that the legal system treats it is that an author is entitled to generally around 170 years protection over whatever work they make, plus any potential spin-offs of it. Just because you thought of a really good idea for a sequel to Game of Thrones doesn't mean that George R.R. Martin hasn't already thought of it and is planning to do it 50 years from now.
Mm-hmm. And this is actually a good lead in. Retronator in the chat said he got a DMCA for his tribute poster from some Warner Brothers lawyers. So what exactly, with that said, what exactly is DMCA for those who haven't experienced it, and how is it used?
Well, the DMCA is the piece of legislation that we have that covers most copyright issues on the internet. It's the Digital Millennium Copyright Act, and it sets up a basic set of parameters for, most importantly, notice and takedown procedures. In exchange for internet service providers, search engines, and websites to get immunity for inadvertently hosting copyright infringement content that might be infringing on anyone's copyrights, they have a legal burden to take content down as soon as they receive notice of infringement. So say someone uploads music or video that they don't own to YouTube. If the copyright holder on that music or video calls YouTube and said, hey, you're hosting this infringing content, YouTube will take it down immediately, and then we'll start turning on an investigation over whether or not it's a fair use, whether or not someone has a legitimate purpose for using that content without a license. And
fair use is such a gray area still, because apparently people refuse to clarify it more in the justice system, at least it seems to me. But so you can clarify it yourself as far as you can. What is fair use actually?
Fair use is a very narrow scope of affirmative defenses to copyright infringement. Basically what that means in layman's terms is you've already infringed on a particular work. You've copied some music, you've copied some video, you've copied some text, you've put it somewhere you're not supposed to, without permission, without a license. But because you have one of several legitimate reasons for doing so, you kind of get a free pass. An example that I always like to use is if a newspaper is writing a review or providing commentary on a baseball game, they might want to include a photo of the baseball game. There's a couple different classes of uses that fall under fair use, including academic or journalistic. So in video games, where this comes up a lot is you have Twitch streamers and YouTube reviewers doing reviews of video games, and they want to include their own streams of their Twitch channel playing the game. They want to include screenshots. They want to include music so that they can, speak over it and sync with it so that viewers get a good idea of what they're talking about. There becomes a very fine line between what's fair use and what's commercial use there, because depending how much new information, how much transformative information they're adding to that video, it might take on an entirely new character. It'll be more of a review. People might be watching PewDiePie for his commentary and his jokes and what he's saying more than actually watching the the stream video that he's showing. On the other hand, if someone's not adding a lot of content to some video, if they're not adding commentary, if they're not adding something new, and they're just showing a game from start to finish, especially a narrative game like this Dragon Cancer, people are now watching it for the streamed content, not the commentary. So that's a lot less transformative, and it swings the opposite way away from a fair use.
Right. And it also kind of depends on the devs, giving those letters on their website saying that they're allowed to use it or not. So that probably adds to that. Now, switching subjects a little bit to trademarks, there's a couple of questions in chat. There's one from Garrett Polk. He wants to know, what are the realistic downsides for not registering a game's name as a trademark? Because so many indie games don't sell well, and he's worried that it will be a waste of money.
Okay, so
Suzanne, you want to take it away?
Yeah, I guess we can start with the basics of what is trademark for those of the folks watching that aren't quite sure about the difference between copyright and trademark. Trademark protects what tells customers where something is coming from. So your company name, your game name, Xbox, Coca-Cola, the Valve logo, which is amazing. I'm a Valve fangirl, sorry. And it can go on literally forever, assuming you keep up with your renewals and continue using it in commerce. Now, using it in commerce is the important part. You actually have to sell something using that name or image for it to count. Now, registering a trademark grants you additional rights, the most notable of which is that it's recognized throughout the U.S. So trademark, like copyright, exists as soon as you sell something. So if I sell a game named Video Game Law Dungeon Crawl, which may happen at some day in the future, which is descriptive and wouldn't get through, but pretend I could. Then wherever I sold a copy, I would have trademark protection for that name. If I register it, though, that name is protected throughout all 50 states. So no one in California or Nevada, for instance, could come in and say, hey, I'm also selling Video Game Law Dungeon Crawl. Ross, you want to add anything?
I think you covered it pretty well.
And did you explain yet how to actually get the trademark?
No, I haven't.
Okay.
So, contact a lawyer. Copyright is a single form and trademark is a single form. Trademark is a single form through the USPTO website, and it can cost anywhere from $225 to $500 depending on how you file. And the form is relatively straightforward. You say who you are, what you are, you submit a picture or the name of the trademark and where you would like stuff to be sent if there's an issue. The problem arises when there is an issue. So, for example, Video Game Law Dungeon Crawl is descriptive of the kind of game I'm making, so the trademark office would call me up and say, hey, this is descriptive, we deny your application. And then all of your fees just kind of disappear into the governmental ether, and you never see them again. If I had spoken to a lawyer before filing that trademark, they probably would have said, hey, so that's descriptive and it's not going to make it through. And sorry, I'm watching chat, it's distracting. And so then I would have saved myself that money, and I would have gotten my trademark through much more quickly and easily.
All right, what you probably saw in chat was the question, are descriptive names like Farm Simulator, 20 whatever, trademarkable?
It depends on, what's the word, Ross?
Secondary meaning.
Yeah.
Whether or not a term... So... The key when it comes to trademarks is how descriptive and distinctive something is, and whether or not it makes you immediately have a gut check reaction to it. If you see a name and you automatically know who it's coming from, who makes it, what the origin of source is, that chances are that's going to be trademarkable. Now, what Suzanne was talking about is very generic terms, like Video Game Law Dungeon Crawl. It's named after exactly what it is. The Chicago Video Game Law Summit, which Suzanne and I organized, named after exactly what it is. It's not a very unique name. When you get things like Farming Simulator 2020 or titles like that, they're very, very generic. So there's a very good chance at first blush for the first title, the USPTO would probably deny a mark that generic. However, after they keep on releasing games and after the brand grows and people start to know and identify that Farming Simulator is made by a particular company, it's released in a particular market, played by certain people, when you have a brand of consumers that are sophisticated enough to identify it, then you achieve a level of secondary meaning, and you might be able to get a very generic name.
On the topic of genericism, actually, at a certain point, some terms can become generic, even if they weren't originally generic. For example, Kleenex doesn't necessarily refer to the Kleenex brand tissue anymore. Kleenex is used as a generic term. And while Kleenex has managed to maintain their trademark, some companies have lost their trademarks due to genericism. There was actually a lawsuit recently against Google because Google has fallen into the regular lexicon to mean to search for something, even if you're using Bing, which some people apparently do. So there's always the concern of having your trademark become so popular that it becomes generic for an entire large group of things, and then losing that protection.
I think Google was actually added into the English dictionary, wasn't it?
Yeah.
Yeah. So I mean, that probably didn't help. So you mentioned trademark actually happens after you release something, or at least the protection does. But to get in all 50 states, like, is there a specific time someone should, throughout their development process or anything like that, that they should get the trademark?
So this depends on who you are and what you're doing. If you have a really great name and you super want to protect it, make a sale to someone so that it has use in commerce, and then get that trademark protection as early as possible. If your name is really good but it relates to your game and you're not really telling anyone, then verging on giving advice to folks, you have some more wiggle room in when you register. It's an important step in preparing, but it's not the most important step. And it's a more expensive one, and we understand that. So it's not necessarily the best place to start.
Okay. So here's a question that's a little bit more topical. So why are folks allowed to trademark things like Saga, in the case of Candy Saga versus Banner Saga, or Ghost, Haunted House, React, or another one that was recent, No Man's Sky, having that issue with Sky Network or Sky TV or whatever it was?
Ross, you love the news. You want to comment on this one?
The short answer is they're not going to be able to do that anymore. There's a very strong groundswell of gamers and lawyers who are resisting that kind of registration. Because if you can't use the word Saga in your video game, what are you going to do? There are so many games out there that use the word Saga and have been using them since the beginning of video games that was definitely an overreach. As attorneys' first job is to cater to what their clients need them to do, and after that to achieve the best protections possible. So when it comes to intellectual property, you have to be very proactive in pursuing trademarks and to enforcing them against other people. It's very much a if you don't use it, you lose it situation. So when it comes to trademark infringement, you want to get the farthest reaching protections possible. So that's what they were trying to do in that case. They were trying to get the word Saga, they were trying to get the word candy. Even Let's Play is a phrase that some people tried to trademark lately. And that's a strong business decision. And for certain companies, registering trademarks is a very inexpensive way to, throw spaghetti at the wall and see if it sticks. Sometimes it works out, sometimes it doesn't. I think that you always have to decide what not only the legal ramifications are of any work that you're doing, but also the PR and business ramifications are of what you're doing. In that case, it backfired kind of on every front.
So we also see see these issues a lot with international companies, because the EU system for registering trademarks is very different from the US system, where in the US you have to use it in commerce and you have to make all kinds of approvals saying that you're the one using it in commerce and blah, 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 blah. In a lot of EU and Asian systems, you could just go in and you say, I want to trademark the word Apple. And if it's available, they just let you trademark the word Apple. And then whoever needs that trademark just has to come to you and pay you whatever it is you want. So maybe the word Saga UK trademark through King was trademarked just by walking in and say, I want to trademark the word Saga, and they said, okay, it's available, here you go. And then they tried transferring that directly over to the US and encountered the differences in the system.
Okay. Well, I have a question about that too. What about like hashtags on media? So just to give an example, because this made me curious, we use hashtag IRX16. There's another expo called Internet Retailing Expo that uses the same hashtag, and if they wanted to, would they be able to trademark that?
So that's a big question of first in use and all kinds of really specific examples, but you can trademark like handles on social media and everything else. For example, Walmart has the right to hunt you down and take the Twitter handle at Walmart if they so choose because you're using their trademark. I assume that would extend to hashtags. Ross, you want to comment?
I think that you're right. My gut tells me that you could trademark a hashtag if it became popular enough. Again, the whole driving force behind trademarks is brand recognition. So if a hashtag becomes a brand that people identify and they know that a particular quality of goods or commentary comes from that hashtag, I think that it could be something you would want to trademark.
Especially when it starts to, like, one buries the other or something like that on Twitter. So I was just kind of curious about that.
Do you guys overlap in timelines so that might be an issue? Because,
Slightly, actually.
You might know some lawyers.
We're burying them currently, but the expo is over for them, so that's, we'll see. But anyway, moving on to another topic, the right of publicity. What is the right of publicity, and why should game devs care?
Right of publicity is becoming a much hotter topic than it has been in years past, specifically because games are giving it so much publicity. The right of publicity comes out of the right of privacy, which is essentially that the Constitution recognizes a right in you to lead a private life and maintain certain aspects of your life privately. So when that comes into play for video games and the right of publicity is when someone is appropriating someone else's likeness, the way that they look, the way that they sound, even the way that they smell. All of those things could be protectable under a right of publicity. So practically the way that this happens is a game developer might include a 3D model of a person in their game who bears a very striking resemblance to a celebrity. Or they might straight up put the celebrity in their video game without permission. Since celebrities, actors, musicians, anyone in the public eye is also in the business of monetizing their likeness, their smell, their sound, their actions, whatever it is that they do, it becomes a commercial use, and it's something that they can enforce. So a lot of lawsuits lately have featured the right of publicity. Lindsay Lohan sued the makers of Grand Theft Auto because she felt that a character in the game bore a striking similarity to her personality and also her look. We've seen this happen with college sports games where athletes are being featured in games very realistically, the way that they look, and not being compensated. And we are still waiting on a very definitive decision that says when and where you can't include celebrities in games. But my hunch would be that since so many celebrities are now jumping on board with being willingly involved in video games, doing voiceover work, doing character modeling, I think that we're going to see a point where you'd be very free to put celebrities in games as long as you compensate them like any other artist, as any other team member.
So where, this outside question, where would politicians fall? Because, for example, Surgeon Simulator recently put Donald Trump in their game. Mm-hmm. He's a politician, but at the same time a celebrity. But I would assume now he would be considered a politician since he's a freaking candidate. Then would he be allowed to, since he's not actually supposed to be making profit as a politician from that, would he be allowed to sue that?
It depends. Trump's a very sue-happy guy. You bring up a very hot topic right now, because the thing that I love about video games, that I love about video game law, is that you have so many different concentrations and practices of law kind of competing for who's going to win out. You have copyright law, you have trademarks, you have patents, and you have the right of publicity, and you have free speech issues. And all of those cross over in very interesting ways where it becomes very murky to figure out what's the right thing to do. When it comes to including politicians in games, putting Trump in a game, I think that, of course, as a person, he would like to have some privacy over his own life. Lately, I don't think he's doing that so much. But at the same time, you have to kind of balance someone's free speech, their right to provide commentary on someone else, and their right to express themselves freely under the First Amendment. So that's where you start getting into it. The way it kind of comes down, if there was a showdown, it would be right of publicity versus right of free speech. And when you start talking about free speech and copyright, you also start talking about parody and fair use, and that's when everything kind of goes to hell.
So, I mean, that kind of leads into, how does it work for people who aren't famous? Like if you want to use a friend in a game or something like that. Also, historical figures who maybe aren't necessarily alive still.
Mm-hmm. And that's happened a couple times. We've had some lawsuits recently that are implicating the right of publicity for postmortem. The History Channel made a game not too long ago featuring General George S. Patton, and we would have thought they would have been in the clear because, one, he's deceased, and two, he's a very historical figure. But at the same time, he's also kind of a modern celebrity historical figure. There have been numerous films and all kinds of content made about Patton. And his estate felt that they should have been compensated for his inclusion in this work. And the legal system isn't exactly sure yet, or at least the circuits are very split, on whether or not you're treating a game as a commercial product that's like a coffee mug, or are you treating it like a documentary film or biopic, which is free expression and very newsworthy. And that distinction, that separation, becomes very important when you start considering whether or not this is a commercial use or whether or not this is research and academic.
Okay. Before we move on to the next subject, Garrett Polkin in the chat asked how he can tell if his game infringes on a patent.
So we actively did not include patents in this particular question lineup because we assume that no one watching this chat right now has enough money lying around to talk about patents. It's an incredibly expensive thing to get into patent litigation, which is why so many patent trolls just send out letters asking for $5,000 because that's a pittance compared to actually litigating through a patent. The sad truth is, it's almost impossible to tell that your game infringes on absolutely zero other patents. You would have to literally search through the entire patent database and have enough technical knowledge to determine whether or not your game fits within the descriptive limitations of those patents. And even if you're an inventor on 3 patents, some of the patents are going to be related to technical things that you are not necessarily an inventor in. For example, I think there was a patent floating around for a while for things like the file bar up top, where you can control different mechanics using a small bar at the top of the screen and things like that, where it's just a thing that everyone uses, and a lot of those patents lie dormant. But if a patent troll were to get a hold of them, all of us would be getting letters. So
all right, well, the next topic is esports. What legal issues come up most often in esports?
All of them.
There's a lot of drama now.
Esports is a mess. Yeah. It's one of my favorite messes. So one of the first problems that came up with esports was just employment contracts. You have professional gamers playing. Some of them are part of leagues. Some of them are directly sponsored by game makers or hardware manufacturers. And a lot of people want to be part of the esports scene. A lot of people want to be professional gamers. It's a kind of a dream job for a lot of people. And it's a very young industry, both that the industry itself is only as old as video games are, and literally that a lot of the players are very young. Most of your esports players are under 25. Most of them are in their teens, actually. So when you have very charismatic, very optimistic, and dare I say sometimes naive people who really want to play video games, sometimes they take deals that they shouldn't. And a lot of those employment contracts have been very one-sided. So you have an industry where esports players and professional competitors aren't being compensated the way that they should. They aren't being paid fair wages. They aren't being flown where they need to be. And not everything's on the up and up all the time. That's getting a lot better, though. As awareness about esports is getting more and more mainstream, ESPN carries esports now, and a lot of video game lawyers are getting very active in this field. Now we're getting to a point where esports are getting a little bit more regulated, so players are treated a little bit more fairly. Another aspect of esports that's caused a lot of legal headaches has been gambling regulations, which vary so widely from state to state. Something as simple as an in-game slot machine that turns out an in-game currency could be a gambling device and could be subject to different regulation in all 50 states and internationally. And a lot of times your average small developer or even a AAA studio might not be cognizant of all of the nuances in gambling law that are changing all of the time. So when it comes to esports, it's the Wild West. It's an all new place.
And speaking about gambling in the U.S. too, it's particularly hard just because of the various state laws. Because this is not really games, but like the sports with FanDuels and stuff like that. That was something that was like New York banned it, while Nevada was like, I want a cut of the money, and other states, I don't care, And then here's another thing leading into gambling. Recently, there was a whole issue with Counter-Strike Go, Lotto, and a lot of those gambling sites, and how Steam is getting sued for, they have lawsuits against them for supposedly fostering that and providing people under 18 ways to gamble. And kind of getting them maybe addicted to it. So what's the whole disclosure issue with Counter-Strike Go and that whole spiel.
In this industry, you have to disclose, like any other, video games aren't special for everything. You have to disclose who your sponsors are, who your endorsers are, especially if you're giving reviews of products. You always want to be as fair and unbiased as you possibly can. So something as simple as if you get sent a piece of video game hardware to review and you don't disclose that you got it for free from the maker, you could potentially be in some hot water. And then everything that's happening with Valve is even more high profile because not only are you having gambling issues where you have a potentially unregistered, unlicensed gaming device in the way of your game, but you also have people under 18. You also have minors playing that game. And anything could be a gaming device when it comes to video games. If you're handing out exclusive account-bound pets, that could be a prize. That could be a payout. If you're handing out in-game currency that is transferable or convertible into a real-world currency, I mean, now you're talking about things like money laundering that you have to be aware of. So it gets to be a very sticky point, and I'm not as on the up with privacy protections as Suzanne is. Suzanne is kind of our privacy expert, so I know that she can talk a little bit more about how this affects minors under COPPA.
Do you want that right now, or do you want to wait for the privacy section?
That's up to you.
I'll wait.
Okay.
I'll let Ross talk about esports.
All right, then the next question is, if someone wants to make an esports game, and actually we had a game called Core Grounds previously in the last exhibit, I think, that wants to turn it into kind of an esports thing, what kind of legal issues should they be concerned about when developing it?
Everything that we've talked about. It's not our job to scare anybody here into thinking that they have to lawyer up immediately anytime they do something. We're fully cognizant of the fact that small developers are in the business of making games, not reading up on law and becoming lawyers. So, but it would be a good practice, without giving advice, to just be cognizant of some of the things that we talked about. If you're making a game that includes gaming, that includes gambling, that includes an in-game currency, as always, talk to a lawyer.
Another thing to remain cognizant of is banking responsibilities. Basically, if you have an in-game currency or an in-game thing that you can cash out, so if I can buy coins in your game, but then if I don't use all my coins and I want my money back and I can get $5 on every $10 back out, that actually puts you up for being eligible for banking regulations, and those are really intense and not something you want to get involved in. So if people are giving you money to buy something in game, it's usually wise, unless you are ready to comply with those responsibilities, not to allow them to sell those things and make real money.
So switching subjects again, we're going to go on to contracts.
Yes.
So do devs really need contracts, especially if it's like a small project and they're all super good friend time, just as legal?
And nothing will ever go wrong because we've been best friends since the 3rd grade, and it's all wonderful. Absolutely. Please, 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 please have contracts. And having contracts, well, I will always suggest speaking to a lawyer, because that will get you the best contract, the most enforceable contract, the contract that absolutely does what you intend it to do. Even writing something down, keeping track of things via email, having some written record of what you agreed to in terms of workload, in terms of profit sharing, in terms of what happens if one friend suddenly hates you all and sets the building on fire, who is owed money. Those kinds of things are super important to have in writing in case things go wrong, because things do go wrong. People are human, so it's a problem that needs to be addressed. Also, when releasing a game to the public, it's important to let them know what they can expect. Can you just delete their account without telling them? Under what circumstances can you delete their account? All of those kinds of things that let them know your relationship. Contracts are basically a written outline of what your relationship with other people are.
And I think there's kind of a stigma attached to contracts too, why people don't do it with their friends, because it's like, oh, well, what, you don't trust me, And they think it's going to hurt their friendship in that way. But, I mean, it's nothing personal, right? It's just
it's kind of like a prenup, right? You never know. Something may go wrong, and it may not even be that person's fault. For example, if they get offered a job with their dream company 5 states away and are just going to leave you with this half-done game, it would be really nice to know that you own all of the assets to that game before they leave.
Okay.
Or how much you have to pay them to own all of the assets to that game before they leave.
All right. So we can... what time are we? We got still 10 minutes, so we're good.
Yeah.
What kind of contracts are most important for
Most
development?
important.
Yeah.
So you're going to want contracts between all of the people that are developing it. That means like your core team contracts that say who's working together on what. You're going to want contractor agreements for folks that you're reaching out to in terms building on fire class. Yes. In terms of who you're hiring to maybe do just your art or just this one sound effect, and what they're getting paid, and whether or not they can use that sound effect in other games, whether or not there are royalties on the project long term, things of that nature. You're also going to want non-disclosure agreements for playtesting and things like that. Ross, do you know of any other contracts that you're going to want early on in the game?
Oh, you covered most of them, but
Okay.
it can't hurt. Having a contract, even spelling out simple things, everything that Suzanne was talking about, who owns what assets, the burn rate for how much time you're going to be spending on a particular project, what deliverables are going to be due when, how much you're getting paid for those, equity shares in a company if you're doing an indie studio. It can't hurt you to have that on paper. And if you have the kind of friends who are like don't trust you enough to put things in writing, maybe you shouldn't be working together. Maybe you guys should just be friends, because spelling everything out, I mean, put hearts and flowers on it. It can't hurt.
I mean, it's safe to assume all of you have development docs outlining what features are going to be added at what point and what kind of characters you want and things of that nature. Just consider this an extension of your development doc, saying who's going to work for how long on what, and whether the company owns that or a particular person owns that, or like it's shared between you in some weird percentage point. And things of that nature. And when you get to the point where you're getting these big contracts from publishers or whoever, please speak to a lawyer. There's a lot of things buried in there that you might not be aware of, or that might seem innocuous at the get-go, but are not necessarily innocuous in certain positions.
Speaking of things buried, what are some notable clauses in contracts?
Termination. So if you're going in for a contract and you don't have the right to terminate, only they have the right to terminate, which means that only they have the right to be like, sorry, this isn't working out, goodbye, but you're stuck in the contract forever. That's concerning. Non-competes in employment agreements. So if you're a dev working on a side project and you have a day job also being a dev, your company may own what you make, which is fun. Ross, anything else that you would really watch out for?
Oh, of course. Jurisdiction is always important, and binding arbitration. So if your contract is with people working out of state, knowing which state is going to control legally is very important to know. Also, assignment is very important. If someone is working on the project and they decide they don't want to be working with you anymore, can they shuffle that work off to someone else that you don't approve at their own discretion? You might not want someone else working on a project when you paid a premium to get this particular person to do something. Zed's absolutely right. Termination, one of the most important things, especially without cause termination, being able to walk away from a project without cause, and usually if there is any mandatory compensation involved, if you have to pay for a certain amount of work that's done up until that point, or if the contract's null completely and you can all walk away.
Also, indemnification,
Yes.
which is where you're required to step into the shoes of the other party. So if I had you guys indemnify me for this stream, and I said something just awful and false about, for example, Activision, and Activision decided to sue me for millions of dollars for ruining their reputation, you guys would have to take on all of those legal costs. And I would just walk away scotch-free, regardless of the outcome, which is a horrifying thought for a lot of people. So make sure you're only indemnifying for the kinds of things that you have some degree of control over.
Yeah, please don't screw us.
Trying not to.
So what is an LLC, and when do people usually form one, and are there any other options as far as forming a company goes?
I know that Ross is just as well versed as I am in all of this, but LLCs and corporations in both their L and C styles vary by state, and the benefits and detriments vary by state. It basically offers a level of protection for you and your assets, so that when something goes wrong and Activision sues you for saying something terrible, they can't take your car and your house. They can only take the assets of that company or entity. The primary difference between a corporation and an LLC is size and taxes, which is something really in-depth and a little bit complicated that you might want to talk to your own lawyer about. Because depending on what your plan is long-term for your game, if you want to stay independent, or if you want to get acquired, or if you would like outside funding, or if you're planning to go Kickstarter, the type of entity you want to form changes. Ross, you want to add anything?
Incorporating is all about forming a liability shield. It's all about protecting your own personal assets from whatever you're doing. You want to keep your finances separate from that of your business. If you're crowdfunding and you're receiving money from people, you want to be putting that money into a separate account from your own finances, because that's going to affect the future of your company, but it's also going to affect your own taxes, because that could be your personal income or it could be your business income. And depending on what kind of entity you have, now your partners might have claim over those assets. So incorporating is always great. Having a liability shield is always great. Unfortunately, for a lot of small-time developers, it's kind of a luxury because it can be expensive. But it's a drop in the bucket compared to some of the liabilities that you would be taking on without that liability shield.
We got about 4 minutes left, so I'm going to skip to data and privacy. How much data can someone collect from their users?
Okay, so this is a big question that starts with the fact that in the US we don't have one privacy directive or privacy law that covers everything. We have a bunch of little privacy laws that not only vary by state but vary by industry. So the answer is as little as you possibly can, for as brief of a time as possible. So only collect information that you need, and only collect it for as little of a time as you're actually using it. For example, give users an opportunity to delete their accounts and know how their information is being used. The best rule of thumb is to write out exactly what data you're collecting and how you're using it and post it on your website in the form of a privacy policy, so that folks are aware of and cognizant of the data you're collecting and how you're using it. If you're using a site internationally, right now is a really interesting time for that, because the privacy shield just went down, and now we have, or safe harbor just went down, and we have privacy shield in its place. So there are some form contracts that you're supposed to use in terms of collecting and storing data from folks that are based in the EU, that you should really speak to a lawyer about, because that is a rapidly changing situation. But in terms of collecting information from US folks, the best rule of thumb is as little as possible, never from folks under 13 without consent from their parents, and for as little time as possible.
What about that data? What about data that's totally anonymous?
Okay, so anonymous data is this amorphous term that's used by the FTC to describe data that has been declared anonymous by an independent data technician. So you would actually have to call someone in to look at your data and be like, that data is anonymous. High five, guys. And it would have to have less than 2 indicators of person and no greater than city geolocators. So it's really specific to say what anonymized data is. If you're just collecting, for example, play session length, that's probably a safe thing to collect in absence of any other data. But if you're collecting something like city, gender, and play session length and play session times, so you know they start playing at 3 p.m., they live in this city, and they're a female, you can get a sense of when they're getting off work or school, and if it's 3 p.m., it's probably school, and then you can kind of build a profile from a certain number of data quantifiers that may seem anonymized by themselves.
Okay. And what? So someone who has an animated game, but it's not targeted at children, should they still worry about people that are under 13?
Yes, absolutely. COPPA has actually gotten mad at Family Guy for producing a game with animated characters, and they determined that it was directed at children under the age of 13. So they needed to ensure a way like gate blocking, age gating. So that's where you have to enter your age before entering certain websites, and things of that nature. Now, we all know kids lie.
Yeah.
Even the FTC has acknowledged the fact that kids are going to lie when they enter their age. It's not your fault if kids lie. If you age gate and a 13-year-old puts in that they're 18, that's not.
I was going to say, like, South Park Stick of Truth is obviously animated, and they probably would consider that. But you know, when there's giant balls coming down on you, you know.
I mean, as long as they're age gating, it's fine. And I mean, they're rated M, so theoretically, that's a problem for the ESRB and parents to duke it out over.
That's why. I mean, idealistically, it should be up to the parents to you know, deal with their kids, but you know, that doesn't always happen. Well,
there are a weird number of folks born on January 1st of the year that makes you 13 or 18 or whatever.
Thank you so much. That's all the time we have for the panel. I'm sure I see there's some other questions in chat. So if you're sticking around, maybe you want to answer those in the chat there. But thank you so much for taking the time again this year to talk about the legal side of developing a game, because it's a huge, complicated mess for a lot of people who didn't go to school for it, and probably for you that did go to school for it too.
Sometimes.
So thank you again for taking the time, and I hope you stick around and enjoy the rest of the expo.
Yeah, totally.
Thanks for having us.
No problem.
Hope to see you next year.
Yes, absolutely. And Suzanne's actually going to be doing another panel later today about TakeThis.org and mental health for developers, so stick around for that as well. And we will go to music, and in the meantime, I will kick you two out of Skype.
Awesome.
All right, bye.
Bye.
Bye.